Could you also confirm that for me, that you are seeking Attorney Kovi to be relieved as your attorney of record for your appeal?
Yes.
For purposes of today's hearing, District Attorney Basie, do you agree, or is there any dispute that Mr. Brooks is indigent?
I have no information to say otherwise.
All right, and do you have any dispute that we are concerned with Mr. Brooks's direct appeal rights at this point?
No concerns.
All right, do you agree with those two issues, Attorney Kovi?
Yes, Judge.
All right.
He's absolutely indigent.
He's in custody. He's serving consecutive life sentences. He's indigent, and initially, even when he was the accused, was eligible for public defender representation. And do you have any information, Attorney Kovi, that would suggest otherwise?
No, Judge.
All right, thank you. Then let me start with some questions. What I intend to do is I want to make a record of a number of things related to the inquiry that this court must make under the law. I think it's important to start with directing the questions to counsel, because as of right now, you do represent Mr. Brooks, and then I intend to address some questions to Mr. Brooks as well. Attorney Kovi, have you received and have you reviewed the February 26, 2025 letter from the State Public Defender's Office?
Yes, I have.
Were you aware or have any knowledge of whether that letter was received by Mr. Brooks?
It's my belief that it was sent to Mr. Brooks and that he has received it. I haven't confirmed that with him personally, though.
All right, I intend to do that in short order. Is it true, Attorney Kovi, that you were appointed for the purposes of investigating and pursuing potentially an appeal for Mr. Brooks on January 6th of 2023?
Yes, Judge. I was appointed for post-conviction and/or appellate relief.
Thank you. And what have you reviewed in your work on this case thus far?
Judge, I have spent probably hundreds of hours. I know this past summer, the vast majority of the summer, my free time was spent reviewing this case, including all of the transcripts, the entire court record, the vast majority of the discovery. I'll make a record of that. There's certainly, when we get provided with lots of audio and video evidence, not all of it is directly relevant to the offense. If, for example, if there's a squad video that's just pointing against the wall, I'm not going to spend hours reviewing that. But the key evidence, the interviews, the court exhibits, I definitely reviewed all of that discovery as well. We have about 5 banker's boxes of materials that I have gone through, including the prior attorney's notes before Mr. Brooks went pro se.
You got enough for a fort.
Have you met with Mr. Brooks either in person, by phone, or in any other way?
Judge, I have, and of course I can't talk about the substance of that, but I have met with them in person several times, plus numerous phone conferences as well. I haven't counted, but a large number of contacts.
Have you had written communication with him as well?
Judge, I'll write him letters. Mr. Brooks and I would generally communicate via the telephone, mostly telephone and in person.
Have you sought a number of extensions from the Court of Appeals related to the timing of filing any post-conviction motion or direct appeal?
Judge, I have basically 2 groups of extensions, if I may explain. The file is huge. And so it definitely took me longer than normal to review the contents of this case. And so the first few extensions were just to get me through the summertime where I was able to review all those banker's boxes of materials. The second set of extensions were filed so that Mr. Brooks, after him and I had fully consulted each other, would have time to decide how to proceed. I know one of my more recent extensions was to give Mr. Brooks the opportunity to try to hire a different attorney if his family was able to do so. That's part of the public record, of course. So those are the 2 groups of extensions that I filed over the course of the last year and a half.
Do you know how many?
The most recent extension was the 7th motion to extend time. That was to give, I'm sorry, my apologies.
The record shows that on
I think there was
February 14th, the 8th motion to extend was filed with the Court of Appeals. Would that seem accurate?
Yeah, I misspoke. It's the 8th motion to give Mr. Brooks time to litigate his case. In the event that I withdraw, he'd have a couple of extra months to review the file and to do his own research.
Again, I understand that you can't discuss confidential communications with Mr. Brooks as his attorney, but generally speaking, have you identified issues to pursue on appeal?
Judge, I can say this. There were several very specific issues that I spent an enormous amount of time researching for appeal as to whether or not there were viable post-conviction or appellate issues. I'm not able to say without breaking privilege.
Have you sent Mr. Brooks any drafts of pleadings related to any appellate or post-conviction issues?
Judge, since I haven't filed an actual appellate brief, we haven't done the notice of intent to appeal, nor an actual post-conviction motion, there wouldn't be any pleadings for me to send him. So we're at the point, if I may, give a little bit more elaboration. Usually it's a two-step process for post-conviction relief. The first part's actually the longest. It's assembling the court materials. I know the court reporter worked exceptionally hard to get me those materials, but that took a few months. Going through those materials, identifying issues that could provide post-conviction relief. In some instances, there are no grounds for post-conviction relief, and then there's a different set of options that I would go through with the client. So after going through all of those steps, I did have multiple contacts with Mr. Brooks, both in person and over the telephone, for him to decide how he wants to proceed. I'm not able, even if hypothetically I found 5 amazing viable grounds for post-conviction relief or appeal, I wouldn't be able to submit any post-conviction motion or notice of appeal without the consent of Mr. Brooks. If I found no grounds for post-conviction relief, then again, Mr. Brooks would have a set of options that I would have to go over with him. And I can say that we have gone through that process, and he has requested to proceed pro se, which would prohibit me from filing any further pleadings in this matter. I hope that clarifies the issue.
Well, it helps because my responsibilities ultimately when discussing with Mr. Brooks is to talk about the options. One option is could be a no merit situation. So I generally just want to know if all options have been discussed with him at this point.
Absolutely, Judge. That I can say 100% certain, and multiple times.
Is it your understanding that Mr. Brooks wants to proceed pro se or on his own, or as he sometimes referred to it as in pro person, I think was the phrase he used with some frequency?
Judge, he does want to represent himself moving forward.
Have you discussed with Mr. Brooks your background
Oh,
as an
sweet
attorney
Jesus.
and doing appellate work?
Judge, I don't, it's such a, it's a innocuous question. There's no issue with me answering it, but I'm afraid that if I were to go into any discussions.
Let me ask it this way.
Yeah.
So I would like Mr. Brooks, and I'd like, actually, let me state it this way. I would like the record to reflect your experience for purposes of my decision here today. So I'll just ask you some general questions. They would not in any way violate any type of attorney-client privilege. First of all, how are you a licensed attorney in the state of Wisconsin?
I hope so. Else I'm in a lot of trouble today. Yes, ma'am.
How long have you been so licensed?
Approximately 20 years, actually 22 years, I believe.
Do you hold licenses in any other states or have permission to appear in any other courts outside the circuit courts, appellate courts, and Supreme Court in the state of Wisconsin?
Judge, I did take and pass the Illinois State Bar, and I was part of that community for a few years. I let that lapse
So did I.
because I solely practiced in Wisconsin.
What about federal courts?
Judge, I was trained to do some federal courts, and I was actually accepted to be an attorney in the Western District. Then COVID struck, and the caseload for the states became so extreme for lack of public defender appointments that I never ended up practicing in federal courts.
Do you have any area that you focus on in your practice?
Judge, I focus mostly on homicides and sexual assaults, if I may. The state public defender's office, let me backtrack. I'm not a public defender. I'm a full-time criminal defense attorney. For most of the last 20 years, I had my own practice. Recently, I joined Kovi for his law firm, CHIRAFISI. For most of the last 10 years or so, I have been
This is the
practicing,
motion in front of
mostly
the
homicide
trial
class
judge.
A, B, and C felonies.
Give me 1 second. Mr.
Sure.
Brooks, would you please direct the camera up? Thank
Motion's
you so
going
much.
on
I
now.
appreciate that.
Judge, the State Public Defender's Office has certifications to take certain levels of felonies. The highest level of certification is Class A felony, and I'm certified to do those in both the appellate and the trial court level. Approximately 20% of my work is with appellate work. I'm in trial more often as with the circuit courts.
In your litigation practice, both in the circuit courts and appellate courts, that's both through appointments and individuals who would privately retain you?
Absolutely. I have the highest level of certifications the Public Defender's Office can give.
Thank you. Have you had any general discussions with Mr. Brooks related to appellate rules and procedures, whether it be formatting, initial briefs, what response briefs are, the requirement for reply briefs, or even the difference between that and a post-conviction motion?
Judge, let me just say this again. I've certainly had lots of conversation with I've spent hours with Mr. Brooks in person and over the telephone. I'm going to speak in very, very general terms. The vast majority of those conversations have to do with the substance of the case itself, the issues that I was researching on this case, and there were some very specific issues which I'm declining to say now for privilege reasons, but that I was researching on this case, going over the case law, meeting with them to discuss lots of different issues. Certainly as part of that, I would have, with every one of my appellate clients, I would have conversations about basic appellate procedures, such as the difference between a post-conviction motion and going straight to the Court of Appeals and why that would occur. That is, as to the details of drafting a brief, rules of citation, the fonts and procedures that you have to do to submit an appellate brief. I, of course, have not had those types of conversations because it was my intent that if there was an appellate issue, I would be drafting that brief. I can say this, and I'm happy to do this to allay the court's concerns. Certainly, it's my intention to send Mr. Brooks a copy of the rules of appellate procedure for Wisconsin. We'll make sure he gets that. Additionally, in my experience of doing this for a long time, though the Court of Appeals will still hold pro se defendants to the letter of the law and the substance of the case, they won't give the pro se defendants any breaks on the substance. If there is an issue with page numbers or citations for a handwritten brief that would be submitted by a prison facility, I've never seen an issue where the Court of Appeals has objected to that. They're a little bit more lenient on those issues for obvious reasons.
Thank you. That was I don't want to say a concern, but a question I had, and that's good to hear. So thank you. Is there anything else you want me to consider in light of the motion that you filed with the court?
Just that I'm not, even if I was allowed to withdraw it today, I'm not going to close the file until Mr. Brooks has the entire file. I was speaking with our paralegal staff just yesterday, going through multiple banker's boxes of materials. The facility where he's being kept at right now will not accept those materials. It's just too much for them to take in. However, if we scan them, download them, and put things on hard drives, multi-gigabyte hard drives, we can send those out. So it will be a very lengthy, time-consuming process for us to do so, but I'll make sure Mr. Brooks gets those materials with one caveat. Because of the time and expense to do that, we wouldn't be making multiple copies. So if something were to occur where Mr. Brooks would want another full set of materials, perhaps 8 months from now, it would be challenging for my firm to comply with that request.
So let me make sure I understand this. The prison facility at which Mr. Brooks is currently serving his sentences will not accept the volume of material that you have in paper or even standalone electronic other than on an external hard drive?
If we sent them disk and flash drives, I'm very confident the prison would accept that. But they made it clear to our office, and it was their staff speaking with my staff, that they would not accept, if I were to ship 5 bankers boxes of materials, they would not accept that. But if we put those materials on computer electronics, then they would have a place where they could store it safely and easily, where Mr. Brooks could access it in their library.
It is not a secret that Mr. Brooks is no longer being held in Wisconsin. If he were in Wisconsin, would you have had better access to him in terms of going to the facility, even with your own computer, and as his attorney showing him discovery if need be?
So I was able to visit Mr. Brooks at the Dodge Correctional Institution, and additionally at the Wisconsin Secure Program Facility in Boscoville. The prison facilities made it very easy for me to do the visits. I was able to bring my case files. I wouldn't have brought that volume of materials to a meeting anyways, had I desired to go through any piece of audio video evidence. There would have been a mechanism for me to do so in Wisconsin. If hypothetically, if I were to remain his attorney, I am able to have telephone and Zoom conversations with my clients. It would be a little bit more onerous for me to do in-person visits.
If you were able to do Zoom, you obviously can
Yeah.
share screen, even information from your computer.
If that's what we wanted to do.
Do you know what, if any, materials Mr. Brooks was able to take with him from his trial to the facility where he is at?
Mr. Brooks might be able to answer this better than I will, but it's my understanding that somehow along the way, when he was transferred out of state, he no longer has those trial materials. So we would be working to give him a complete set of what we have. And that would also include downloading all the materials from the e-file and putting that on a separate flash drive as well.
But you're willing to do all of that?
Yes, we will get extra funding from the Public Defender's Office to get extra paralegal support to do that.
And they're willing to do that as part of the case closure, should this motion be granted?
I have not put in that request yet, but I am certain they'd be willing to do it. They've done it before on other cases that were also very serious cases. I'm sure I can get the funding.
All right, thank you.
And frankly, if we didn't get the funding, we would do it anyways.
Well, I appreciate that. Thank you. All right, Mr. Brooks, I'd like to ask you some questions.
Oh, here we go.
First of all, are you aware that Attorney Kovi has filed a motion to withdraw as your appellate counsel?
Yes.
And just as a reminder, even though I tried my best to talk to you at my cameras, when I want to watch you for your response, I look slightly down and to the right, or even to one of the other monitors that I can look at. So I just want you to be aware that when I do that, I'm actually paying attention to you. Any
She's looking
questions about
down on
that,
you,
sir?
like the rest of us.
All right. Do you want to have Attorney Kovi withdraw and act as your own attorney, sir?
At this time, yes.
The Public Defender's Office sent to this court a letter dated February 26th of 2025. It is front and back. I think the actual filing had some additional information on the third page, but that had more to do with who was copied on the letter versus the crux of the letter. But did you receive a copy of that, sir?
From what was the date?
February 26th of 2025.
I don't believe I received that.
Mr. Brooks, would it be helpful if at this point I switch to a single camera when I'm talking directly with you instead of having the multi-camera view?
I can see you just fine.
Okay, great. So I'm just going to read the letter into the record, sir. It's important. It is from Kelsey Loshaw, the Regional Attorney Manager from the Madison Appellate Office. Does that ring a bell at all?
I think from previous letters it might, yeah.
Well, this one is specific because it was filed after the motion to withdraw was filed, and there's a requirement in Wisconsin Statute 809.30 that the Public Defender's Office advise the court of certain information. Does that help ring a bell, sir?
No.
All right, then bear with me. I will read the letter. It says, "Dear Clerk, in accordance with Wisconsin Statute Rule Section 809.30 sub 4 sub B, I'm writing in response to the motion to withdraw filed by the SPD appointed appellate attorney Michael Kovi. The rule requires the SPD to determine whether successor counsel will be appointed and notify the court of the determination. I ask that you pass this on to the judge assigned to the case because the judge is required by Rule 809.30 sub 4 sub C to consider the SPD's response prior to ruling on the motion. The state public defender informs the court and Mr. Brooks if the motion to withdraw Mr. Brooks' directed attorney Kovi to file is granted, Mr. Brooks will be waiving his right to public defender representation, and no new or successor public defender attorney will be appointed." Sir, have you heard what I just read to you?
Yes,
Are you aware of the risk you take as it relates to to a public defender appointed appellate attorney if this court grants the motion to withdraw?
yes,
Do you have any questions for me about that?
no,
The letter goes on, an indigent person's right to an appointed attorney for appeal does not encompass a right to an attorney of choice or to successive appointments. State v. Evans, 2004, Wisconsin 84, 273, Wisconsin 2nd 192, paragraph 30. If a defendant decides he no longer wants to be represented by an appointed attorney, he has the choice of terminating counsel's representation and proceeding pro se or with retained counsel. Id at paragraph 31. If a defendant elects to discharge his appointed attorney and proceed pro se, the defendant must be provided clear warnings regarding the dangers of self-representation before appellate counsel may withdraw. Id. Sir, did you hear me read the second paragraph of this letter?
yes,
Do you understand it?
yeah,
Do you have any questions for me regarding that?
no,
The letter goes on to provide the legal framework for the court's responsibility in determining whether a defendant validly waives counsel on appeal. And I'm going to read that paragraph. It is a direct quote from a case, State v. Thornton, 2002, Wisconsin Appellate 294, also found at 259, Wisconsin 2nd 157. For your information, State versus Thornton is a Court of Appeals case that dealt with an issue for the first time in Wisconsin in a decision dealing with the court's responsibilities in determining the waiver by a defendant of counsel on appeal. And in that particular case, and this paragraph starts out by giving a little statement about the state's summary of the issues. The state offers the following synthesis of the foregoing decisions. Before a court may conclude that a criminal defendant has knowingly and voluntarily waived his or her right to counsel on direct appeal, it must satisfy itself that the defendant is aware, one, of the Flores rights, parenthesis, to an appeal, to the assistance of counsel for the appeal, and to opt for a no merit report, parenthesis, two, of the dangers and disadvantages of proceeding pro se, and three, of the possibility that if appointed counsel is permitted to withdraw, successor counsel may not be appointed to represent the defendant in the appeal. The court went on, we agree with the state that ensuring a defendant has received and understands the listed information is both necessary and sufficient to support a determination that the defendant tendered waiver of counsel is knowing and voluntary. In that particular case, the issue or the procedural posture was that the appeal was already pending. And so the Court of Appeals had some further things to say about the communication with the defendant being written. That's not applicable here. I'm having a over Zoom face-to-face discussion with you, but this is the framework that will guide the questions that I ask. Do you understand that, sir?
Yeah, I'm familiar with that case law as well.
Thank you. Any questions for me thus far?
Nope.
All right. So I just want to confirm, sir, did you ask Attorney Kovi to withdraw?
Yes,
Did he send you a copy of the motion to withdraw?
yes,
Have you reviewed it?
yes,
Do you have any questions about it?
no,
Do you take any issue or claim made by Attorney Kovi in dispute?
no,
Did you at any point in time tell Attorney Kovi you're fired?
no.
All right.
Judge, if I could just clarify something. The conversations I've had with Mr. Brooks in every instance, they were quite respectful. There was no arguments. So when Mr. Brooks would ask me, when he asked me to withdraw, it was in a polite, respectful way as opposed to a "you're fired, get out."
Great, thank you. I appreciate that clarification. I still wanted to ask from
Sure.
his perspective. All right. Any dispute with what Attorney Kovi just said, Mr. Brooks?
None whatsoever.
All right. Why do you want Attorney Kovi to withdraw?
Judge, if I may, Mr. Brooks, this question could cause into some privileged information. You have every right to answer the question. You and I have had lengthy conversations about the substance of particular issues that I have looked at and my conclusions on those issues. I don't think it would be to your advantage to go in that direction. You can definitely answer the judge's questions, but I would just be guarded as to going to the substance of any legal research that I may have done, that I did do. Thank you, Judge.
You're welcome. I appreciate that. I can ask it in a more general way. Mr. Brooks, again, understanding the caveat that your attorney has given you, how would you characterize in general terms the reason you want to proceed pro se? Is it a strategy disagreement, or do you simply just want to represent yourself pro se?
I just want to represent myself.
So let me ask you some real specific questions then about some access to research materials and other things.
He was awesome at
I
trial,
believe
Judge.
these questions go to your understanding of the difficulties and disadvantages as a pro se appellate litigant. Most of the time, well, if you file in the Court of Appeals, it is a written process that may or may not include appellate arguments in front of the court. Do you understand that?
Briefly, I understand the outline of what you're saying. Yeah.
So you're prepared to follow the rules and procedure of appellate procedure and submit written submissions, whether it be to the trial court or to the appellate court related to your post-conviction and appellate rights.
Yes.
Do you have, or what access do you have to legal research at the institution at which you are currently serving your sentences?
Honestly, not very much. It's very different. So it would take some time, and maybe a few conversations can be had in that area. But I mean, I don't know if that answers your question.
You've answered it. Thank you. Do you understand that could lead to further delays in your appeal or post-conviction motion?
Yeah, I do understand that. I kind of anticipate that with where I'm housed. It's like I said, it's a lot different. Things are done totally different here. So I'm aware that that could pose some issues.
You don't dispute that you're no longer in Wisconsin serving your sentences, correct?
I'm sorry, can you repeat that?
You agree, I earlier said you're no longer in Wisconsin serving your sentences. That's true?
I would rather not say. Or
Judge, I can verify that he is no longer in Wisconsin. The Department of Corrections had requested me personally not to disclose his location. Of course, it's up to the court. I'm sure at some point it's going to get out, but I just had a conversation.
Let me answer that for a second, because
Sure.
we can take a brief segue.
Sure.
I am treating Mr. Brooks no differently than I would treat any individual who's serving a sentence in the state of Wisconsin. I repeatedly asked the Department of Corrections for information where he was at. I am a separate but equal branch of government, and they thwarted my efforts. I was only told he's in South Dakota and given email addresses for individuals that we could have contact. I need to be able, as the court, to send communication to him directly. That would be no different for any other inmate in the state of Wisconsin, whether they have an attorney or not. So today I directed my clerk to send an email to South Dakota and ask them for the information. It was provided and it is on CCAP. I have received no requests to seal an address. I have received no legal authority from anyone and no request. And so I'm treating Mr. Brooks the same that I would treat any individual, and that information is now on CCAP.
Thank you, Judge.
Mr. Brooks, do you believe that despite some of the challenges that you described, or at least stated about access to research, that you'll be able to overcome that if you are representing yourself?
I mean, like I said, it's going to be difficult, but there are conversations that I'm sure can be had to aid me along the way. But I mean, I have to be honest and say that it will be very difficult.
But do you understand that's the risk you willingly take if you want to be your own attorney and proceed pro se?
It's a risk. It's a risk regardless whether I was in Wisconsin or not. It's just going to be, the question was based on where I'm currently housed, which is more difficult than if I was still housed in Wisconsin.
I understand what you're saying. I'm aware, but do you acknowledge, sir, that that is a risk that you willingly take by asking if I approve the motion to withdraw and you appear as your own, you proceed as your own attorney? You understand that?
Yes.
All right. And again, I'm not trying to be nitpicky here. I'm trying to make a record, and I believe it goes to the dangers and disadvantages of being a pro se appellate litigant who is serving multiple consecutive life sentences, meaning you're in custody further complicated by the fact that you're serving those out of state and you don't apparently have the same access to resources as you would in Wisconsin. Do you disagree with anything that I just said?
No.
I want you to be aware, sir, that you have the right to counsel on direct appeal. Do you understand that?
Yes.
Do you have any questions for me about that?
No.
As you know, Attorney Kovi was appointed by the State Public Defender's Office, meaning at the government's expense, to investigate and review your appellate options. And that the Public Defender's Office, through that letter that I read to you, has advised they will not appoint successor counsel under really any circumstances. Do you understand that? You want me to restate that?
No, I said yes.
Oh, I'm sorry, I didn't hear you. You covered your mouth, so I couldn't even see your mouth moving. All right, you understand that, sir?
Yes.
Do you have any questions about that for me, sir?
No.
The right to counsel in this circumstance, and I'm referring to not only 809.30, but the Wisconsin Constitution, Article 1, Section 21, includes the right to a direct appeal, the right to assistance of counsel for the appeal, and includes such thing as the right to opt for a no merit report and abandon an appeal, essentially. Do you understand all of those things?
Yes. Yes.
Thank you. The right to counsel, however, does not include the right to appointed counsel of your choosing. Do you understand that?
Yes.
It also does not include the right to insist that your appellate attorney pursue issues which he in his professional judgment choose not to advance. Do you understand that?
Yes.
In other words, if the only dispute, let's say, is over strategy and you change your mind later on, that's in that circumstance, the SPD will likely not reappoint. I mean, they've said that in their letter. You can change your mind, you can have remorse, regret, you could try to find your own retained attorney, and if that doesn't work out, that once this court grants the motion to withdraw, they will not appoint successor counsel. Do you understand that?
Yes. And to be clear, there was no disputes between me and Attorney Kovi. So there was no strategy disputes. There was nothing of the sort.
Sir, I know from presiding over a previous hearing related to the waiver of attorney that we spent a fair amount of time going through your background. And I just want to confirm a few things with you. You can read, write, and understand the English language.
Yes.
You completed high school through the 11th grade and obtained an HSED. Is that also true?
GED.
A GED. All right, thank you. Are you currently taking any medications that would interfere with your ability to understand what is going on?
Not currently, no.
All right, do you have any medical issues that would interfere with your ability to understand what's going on today?
No.
Are you under the influence of any alcohol or drugs today?
No.
It is also true that throughout the trial in this case, you represented yourself.
Yes, that's true.
Is there anything about this court hearing thus far that you have not understood?
No.
I dispute that.
Are you asking this court to allow Attorney Kovi to withdraw as your attorney of record?
Yes.
If you change your mind, I want to confirm once again that you are aware the Public Defender's Office will not appoint successor counsel.
Yes,
Are you aware that if you can't hire or retain an attorney on your own, the Public Defender's Office will not appoint successor counsel?
yes,
Do you understand, sir, that you will be responsible for all aspects of your post-conviction litigation and appeal, including compliance with all court rules and procedures?
yes,
Anyone make any threats or force you in any way to waive your right to an attorney in this case?
no,
Anyone make any promises to you in exchange for your waiver of right to an attorney?
no,
Do you believe you're making the decision to waive your right to an attorney freely, voluntarily, and intelligently?
yes.
Do you need any more time to talk to Attorney Kovi regarding your request that he withdraw?
No,
Do you further understand you may need to file motions in the Court of Appeals seeking an extension of time? Given the most recent extension goes to June 3 of 2025.
yes, I'm aware. I didn't know it was that soon, but yes, I do understand that.
Judge, may I jump in for 1 second?
You may.
Thank you. And just for the record, we have sent Mr. Brooks copies of all of our extension motions and the Court of Appeals decisions. What I will do for Mr. Brooks is I'll send him again that my most recent extension motion that he can use as a template. And I'll include a closing letter with the instructions as to how to file that and to use a pre-appeal case number, some of the basic procedural issues that might help him understand the difference between a post-conviction motion and going straight to the court. Is, from my experience, the Court of Appeals is pretty lenient in giving at least several extension motions to pro se defendants. At some point, they'll put some harsher deadlines on. It's a gray area, but I am very, very confident that he'll have more time than June 3rd if he makes a proper request to have more time. It might take a couple of weeks for us just to get at those files to him. We've been working on it.
Mr. Brooks, do you understand that if the court permits Attorney Kovi to withdraw today, you would be responsible to file the next extension request?
Yes.
And you are prepared to do that?
Well, once I receive the templates that Attorney Kovi is going to send me, yes, I'll be ready to do that.
You understand he's not required to do that. He's just offering to do that, and it would not.
I know.
All right. You understand that's still something you are responsible for, whether he sends you that template or not?
Yes.
Is there anything else you want me to know or consider today, Mr. Brooks, as I consider the motion to withdraw?
Not really. I think everything was pretty much covered. Just understanding should be there that, you know, again, this facility is a lot different. So there are different types of hurdles that I've already seen that I would have to jump over to be able to get things done. So I just want that to be stated for the record, that it's just a lot different, and there's a lot of different procedure wise things here. So I'm still navigating that, as I haven't been here that long. So I'm still learning as I go. So that's it.
And you're willing to take on your own case with that difficulty and those challenges related to the institution?
At this time, yes.
Attorney Kovi, anything you think I've overlooked here today as it relates to this motion?
Judge, I'm very satisfied with the colloquy. I think just to make a record, I have just one other issue. If I may ask Mr. Brooks a quick question.
Go ahead.
Mr. Brooks, I know you talked about that there are some difficulties. I just want to make sure, are you still allowed to have access to your legal files?
So the legal files is something that I haven't been explained. I didn't know that there was conversations about the whole flash file thing. I haven't even heard anything about that. I really don't know how. Somebody maybe here can explain to me how that will work. So I'm kind of like trying to figure it out myself, actually.
Attorney Kovi, it's my understanding, based on what you've said, I mean, you believe the institution will accept the external hard drives, obviously any paper that you send through regular mail, just not banker boxes or large boxes full of materials.
Yes. So if I were to send them a 40-page packet of materials with appellate rules of procedure and extension notes and templates, I think any facility would allow that to be processed through, so long as I don't have clips or staples. As for, but they balked. My initial email, I don't have this memorized. I don't want to make a false statement, but my initial recollection when I first contacted that prison facility was to say that we were going to send them the files. I was told they would accept the file, but then when I stated, or when staff stated that it would be 5 bankers boxes, they put the brakes on that. And then there was some correspondence between their legal staff and my legal staff as to the best way to do this. We'll likely be buying some terabyte hard drives to put the materials on that to send to him. I don't know how much access you'll have to the library. I know in Wisconsin, you can go in almost every prison facility, unless you're in some kind of segregated status for a fight, for example, with another inmate, that you can make reservations to go to a computer library to review your legal documents. I also know that the time is quite heavily rationed. He's not going to have 8 hours at a time to look at these documents. So that will be a challenge for him.
I was just gonna say that too. There's no law library, which I've never seen a jail or a prison without a law library.
No law
So,
library.
I don't know how that's gonna work.
Do you have access to anything through a computer or online to access research material?
I have access to look at I believe it's Westlaw, and those are tablet based. But even that is challenging.
Everybody mark your cards.
I use a tablet-based Lexis. It's a similar platform.
We can only hope
It
for a
can be cumbersome
coercion.
unless you know how to switch to the natural language search engine and how to limit the jurisdictions and what you're looking at.
Oh yeah, he's all over it.
But I think it's similar to what you had when you were in Waukesha, is that not?
No, Waukesha had Lexis, or however you say it, Nexus, or
Oh,
which
they're very similar. If you figured out Lexis, you can figure out Westlaw. In my humble opinion.
Judge, if I may add one thing.
Go ahead.
Mr. Brooks, I know that without going into the substance, I recall about a 2-hour meeting when we went over a large amount of case law together. What I'm happy to do is I can send you those copies of those cases that we discussed.
I appreciate that. Thank you.
Thank you.
Thank you. Mr. Attorney Basie, is there anything the state wants me to consider or any additional information from the state today?
Because
All right,
there was no
then,
death penalty in
as I
Wisconsin.
indicated earlier, and I'll just go through some of the law that pertains to this issue in making my decision. A person convicted in Wisconsin of committing a crime has a constitutionally guaranteed right to appeal his or her conviction. to the appellate courts. That's directly from the Wisconsin Constitution, Article 1, Section 21, and case law State versus Perry, 136, Wisconsin 2nd, 92, a 1987 case. The right to an appeal includes the right that the appeal be a meaningful one. An indigent defendant is constitutionally entitled to the appointment of counsel at public expense for the purpose of prosecuting his or her one and only appeal as of right from a
Appellate
criminal
court's not going to take
conviction.
testimony.
And I'm citing to or from State versus Thornton, and that again is 2002 Wisconsin Appellate 294. And that court was citing to the U.S. Supreme Court in Douglas versus California, 372 U.S. 353 from 1963. There's no dispute here today that Mr. Brooks is indigent. This court has noted previously, I've dealt with this issue with Mr. Brooks previously prior to trial, but a criminal defendant may waive his or her right to counsel in criminal trial court proceedings, provided the record reflects that the waiver is knowingly, intelligently, and voluntarily made, and that the defendant is competent to proceed pro se. That's a citation to State versus Klessig. Appellate or post-conviction counsel appointed by the state public defender may move to withdraw from representation of a client, and in determining the motion, the court shall consider whether the defendant waives the right to counsel, and that's Wisconsin Statute Rule 809.30 sub 4 sub C. As I indicated earlier, at the writing of Thornton, no Wisconsin appellate opinions address the requirements for effecting a valid waiver of appellate counsel. Thornton relied heavily on Oman versus McCoutry, which was, although a Wisconsin case at that point in time, it was before the 7th Circuit Court of Appeals. The citation for that is 130 F 3rd 809 from 1997. I did review that case as well. And from that case, the Thornton court stated and found that before a court may conclude that a criminal defendant has knowingly and voluntarily waived his or her right to counsel on direct appeal, it must satisfy itself that the defendant is aware, one, of the florist rights, which I've talked about, that's the right to an appeal, to the assistance of counsel for the appeal, and to opt for a no merit report that was briefly mentioned previously. 2, the dangers and disadvantages of proceeding pro se, which this court has, I think, exhaustively gone through with Mr. Brooks. And 3, of the possibility that if appointed counsel is permitted to withdraw, successor counsel may not be appointed to represent the defendant in the appeal. We know from the letter from the State Public Defender's Office, they will not appoint successor counsel, and that's a citation to document 690, filed February 26 of 2025. This court is satisfied that Mr. Brooks is freely, voluntarily, and intelligently waiving his right to appellate counsel. He confirmed many of the same requirements, if you will, that I went through with him at the time of his waiver back on September 28th of 2022. I just want to, I'm not going to read the entire excerpt into the record, but I am looking at the transcript, which is document 580 from that hearing, pages 75 through like 77. The court makes some findings that I believe are confirmed here today, and that's, he said today he had a GED that may have been referenced as an HSED. I think they're very similar. Nonetheless, Mr. Brooks has a high school equivalency diploma or a general education diploma. He's been able to communicate very clearly with not only counsel, but with the court. He's done that efficiently and effectively. He did not have questions for the court today. Frankly, this procedure went much more smoothly than the procedure and the questioning and answers back in September of 2022. And So I'm just gonna rely and incorporate herein by reference many of the findings or all of the findings I made back then, because nothing has been presented to this court that would dissuade it otherwise, that he's intelligent, he understands the dangers and disadvantages of proceeding on his own. He's made the request. He now knows the SPD's position. He indicated it doesn't change his mind. We've discussed many of the disadvantages and potential pitfalls of proceeding on his own. He's in an out-of-state facility. He does not have the same access as he does in Wisconsin. We have some wonderful offers by Attorney Kovi to send him additional information. He's aware he needs to file for an extension because the current deadline in the Court of Appeals is June 3 of 2025. So I have met, and through the colloquy here today, the requirements of the Thornton case, and I'm satisfied that he's doing so, again, freely, voluntarily, and intelligently, and with an understanding of really the dangers and disadvantages and of his rights to an appeal and to appellate counsel. And for all of those reasons, the court will grant Attorney Kovi's motion to withdraw. And from here on forward, the court will consider Mr. Brooks a pro se litigant. We will be able to communicate directly with him. I would like an order. I don't recall if you sent a proposed order in, but if you would do that, Attorney Kovi, I will certainly review that, sign it, and then we will send that on to Mr. Brooks.
I'll get that done before the end of the day.
Thank you. Mr. Brooks, anything else from you today? Attorney Kovi?
Judge, I will make a request. Generally, once I'm allowed to withdraw, I'm cut off from the e-filing. I would request that I have the opportunity to send Mr. Brooks all of these materials, that I can file a letter with the court saying that we have done so, make a record of that, and then at that point, perhaps I can be cut off from the e-file if the court so desires. If there is some kind of issue where the prison won't accept anything, for example, then we would be able to address that. I just want to make sure that he gets his materials before I truly end my representation on this case.
You're asking that I delay the approval until you've been able to pull everything off from the court file that you currently have access through as an e-filer.
I guess so. You can sign the order at any time. I don't, and oftentimes I'm kept on the e-filing system even after I've been withdrawn. It's just kind of a quirk of the e-filing system. So we can sign the order at any single time, but I would, as a friend or as a courtesy to the court, I could still draft an update letter letting the court know that these materials got sent out. I'm not trying to complicate it.
That's okay. My clerk is advising me that we can delay removing you even though I signed the order of discharge.
Thank you, Judge.
Any objection from the state?
No, Your Honor.
All right. Anything else from the state today?
No, Your Honor.
All right. Thank you, everyone. That does conclude the hearing today. For purposes of our live stream, we just not turn it off for about 30 seconds or a minute because there's a delay in the broadcast, and we want to make sure everyone gets there
Thank you.
to the end. Thank you,
Judge.
everyone. Good luck to you, Mr. Brooks.
Thank you.
Good luck, sir.
I don't know. I'm saying bad luck to you.
I know. It's sketchy.
All right, there you have it. It wasn't too exciting, but I got it, so I just joined it immediately. We sped it up a little bit in the beginning so we'd catch up to the stream. There are some questions that were going on that were actually pretty good. First of all, I don't know why he kept covering his mouth. I don't know if he lost his teeth or whatever. That just kept going on in the chat, and I don't have any answers. I'm watching the same stream. The other good question is somebody said, because he's out in North Dakota. This appeal's pending in Wisconsin. They're like, is he going to have to go back and forth? Which is a good question. I actually had to think about it for a second. But you really don't have to go back and forth. I've not handled a bunch, but I've handled a handful of appeals in my career. And you never go in front of the appellate court. I mean, it's possible. You may have a clerk status or something outside of this, but basically the only time you go in front of the appellate court is for oral argument. This whole procedure is written. The whole thing. You file an appeal, you draft an appeal, you file it. You say, I want a new trial, whatever the hell you want. You do this and you give a legal basis for it. And then they file a response, and then you file a reply. I'm doing it from his perspective. He would have to file the appeal. He wants to change what happened in court. So the only time he would go, it's still a good question. I don't know if they would drag him back from South Dakota to argue live in front of the appellate court, or they just give him a Zoom link. I don't know. Oh, his end game is dying in prison. There's no doubt about that. Whether he's represented or not or whatever, that's his end game. But that's just my thought. That's the thing too. It's like, I mean, he was god awful at his trial, of course, which didn't matter again because he was so damn guilty. He would have gotten rung up either way, even with a good attorney defending him. Best a good attorney could have done is, and this is a big stretch, but the best thing a good attorney could have done is create enough havoc that he cut him a deal so that maybe there's some slight chance that he sees the light of day before he dies. That's the best I could imagine a fantastic attorney doing. So that's here. I think I will give Darrell Brooks some credit here that he probably doesn't believe, that probably doesn't deserve. But my guess is his assessment is correct. I think he looks at this and says that I have absolutely zero chance of winning this appeal, represented or not. I might as well do it myself because it's the only hobby I'm going to have between now and the day I die in prison. The attorney he had there was excellent. He was really trying to help him. It's very professional of him. He was going above and beyond what he had to do, trying to give him templates to file extensions and all this garbage, which is nice and very professional. But the appeal would be harder because that guy could put together an argument that the state would actually have to think, like, rub their chin about and go, okay, because they would actually cite proper case law and know what might work and might not. I'm no expert on the topic, but I didn't see any good avenue for appeal as I watched the trial. But I'm not looking for that. And that's real nitpicky stuff. You sit there and say, oh, you made a bad ruling on evidence. You allowed stuff in that shouldn't have been because of this or that. This type of stuff. And I wasn't watching it with that in mind. But nothing came out and jumped out to me like, oh my God, they screwed that up. This is going down on appeal. I didn't have that sensation as I watched the trial. So he's going to, I don't know if he's going to continue with soft sit stuff. He wasn't doing that today. He didn't contest jurisdiction. I was sort of disappointed. I just wanted one. Although he actually, he did straighten out Tackett to Tacit. It took him a long time, but he and what he gave us a library today, but he could pronounce jurisdiction better than the guy that I just the one I just did the stream on. The last couple guys have moved to jurisdiction. But no, he gave us that's what when she's like, whoa, I've got some the phrase they used which cracked me up. There's some hurdles to handling this appeal. And the ones they offered were not the ones I was thinking of, which is you're dumb as a rock and guilty as sin. Those are tough hurdles. I hope it's painful for you. That's how I feel about it. That's how I feel about it. So I don't know. The mystery of why he's covering his mouth, I don't know. The speculation is he got some teeth knocked out, but I never got a good enough look to see if that's the case. So there you have it. There you have it. I was not prepared. I was actually putting together a stream for happy hour, which I might do in a little bit here. And then this came up, and I thought, if you're gonna do it, might as well do it timely. So, who sent this to me? I put it in the thing. Heather Ann DeCow sent me this. It's her fault. It's her fault. That's why we're here. I've already added it to my Wisconsin versus Big Dummy, aka Darrell Brooks playlist. Ah, the memories. Thank y'all for coming out. I'll see y'all soon.